Good morning, honorable colleagues and Secretary General. Today's session is broadcast live on Parliament TV on channel 408. We can follow that up. We request all participants and everyone who's on the platform to please use and keep their video on when they take to the platform because we are broadcasting live. We are requested to have the person speaking on screen when we do the broadcast. So we request every participant to please bear that in mind. We are also going to be live streaming the session on the social media platforms of the SADC PF. The session is also going to be live streamed on the platforms of the Parliament of South Africa. All the platforms, the social media platforms, Twitter, Facebook, and YouTube. So we request members to bear that in mind, that when they take to the platform, please keep the videos on. And also, we are going to be using snippets of the contributions that participants are going to be making. We're going to take up short snippets of videos that we're going to be posting them on social media. So we request every time a participant contributes in the meeting to please switch on that video so that we can have that the face behind the voice that is going to be making the contribution and the name. But also in terms of the framing, it's important for participants to please frame themselves properly so that we are able to have nice, clear, quality pictures when we do the framing. I can already see someone who's not framed properly, who's on the follow now. Could I kindly request everyone who's on the platform to please switch on their video so that we can take a picture of the participants, please, and so that we can be able to make some determination in terms of the people who are there, whether they're properly framed or not. Thank you very much. Good morning, SG. I can see you there. Good morning, Madam Eva. Could you please request all the people that are on the platform to switch on their videos? Well done, Madam Hove.
Hello.
Good morning.
Yes.
Good morning.
You are properly framed. Thank you very much.
Thank you.
Can you request some more people to please switch on their cameras? I see a lot of my colleagues on the platform, but they are not switching on their videos as well. Good morning, Carlos. Is it Bom Dia? Thank you very much, Sis Agnes.
As we do this, host, could I be allowed to share, please?
You're able to share.
Thank you very much. Modisa, I presume but some of the participants are still in the makeup room. We shall allow them to make up, and we'll have a photo session in between the meeting.
Thank you very much, Chair.
Sure. Seeing that it's Ronald, I'm struggling to share. I wanted to share the calendar, the consultative meetings calendar. If you're able to share it at short notice, please do so. If not, let me know.
Okay, just a second.
Okay, I'll be able to share, Ronald. It's fine.
Okay.
Thank you so much. So good morning, Secretary General. I wish to recognize Madam Eva Jala, our distinguished legal drafter for this model law. I recognize legal drafters from national parliaments and ministries of justice of SADC member states. I recognize all the distinguished participants in the meeting. My name is Shaunen Kurasha. I'm the program manager for democracy and governance, and also in charge of parliamentary business. I shall be your director of ceremonies for this meeting. This meeting is a meeting for legal drafters from the ministries and from national parliaments to be given an opportunity to be consulted regarding the draft SADC model law on gender-based violence. Just to put things into perspective a bit, to inform distinguished participants that our meeting this morning must be understood within the context of the consultations that SADC PF holds with various stakeholders whenever we are developing model laws. And SADC PF places premium value to such consultations because the legitimacy of both the process and the outcome is hinges on the extent to which we would have consulted with the various stakeholders. After all, these stakeholders are the end users of these model laws. So just for you to appreciate how far we have come, we have held consultations before from the month of August with various stakeholders from the media, with the SADC lawyers, with the human rights commissioners and ombudspersons. We've also consulted with civil society organizations, with judges and jurists and judicial officers. We've consulted with youth, young people. We've consulted with SADC ministers of gender and departments that are responsible for gender, SADC member states. We've also consulted with the police under the SAPCO umbrella. We have had consultations with national parliamentary committees that deal with related matters such as gender, children's rights, legal affairs, police and justice. And today we are meeting with yourselves, the legal drafters, as I said, from the ministries of justice and parliaments. Just to guide us in terms of how we are going to proceed, I will share the program. There we go. Ronald, may I request you share the program, the copy of the program? I'm struggling to again find it. I don't know what's happening to pick it on my Zoom. Thank you so much. Yes. So we will start our meeting with a welcome address that will be delivered by the Secretary General of the SADC Parliamentary Forum, Madame Boemo Sekoma. This will be followed by a presentation of the draft SADC Gbv model law, which will be made by Ms. Eva Jala, the legal drafter for this model law. And that will then be followed by plenary deliberations, wherein the legal drafters are going to make their inputs in terms of comments and proposals for amendment. Just to indicate that legal drafters will have an opportunity to submit, if they wish to submit after the meeting, any further comments or proposals for amendments. You will have until Friday to have submitted these any amendments to the email that I alluded to earlier on, gbv@sadcpf.org. I've pasted the email in the chat box. And also to indicate that we already have received a request from Mauritius to submit their comments after the meeting. There is an opportunity not just for Mauritius, but for everyone, as I've indicated. At this juncture, allow me to officially declare the meeting officially started, and at which point I now invite the Secretary General to deliver her welcome remarks. Over to you, Madam SG.
Good morning, Director of Ceremonies. Thank you for those briefings at the beginning of the meeting. Allow me to recognize Ms. Eva Jala, the draftsperson of the SADC Gbv Model Law, our legal draftspersons from the ministries and national parliaments, colleagues from national parliaments and from the SADC PF, and any distinguished participants who have joined us today. Welcome, bonjour, bon dia. It's with immense appreciation and pleasure that I welcome you to this consultation in my capacity as a Secretary General of the SADC Parliamentary Forum. This consultation today is being held with yourselves as legal drafters from ministries of justice and parliaments or our SADC member states, with a view of ensuring that we work together towards the finalization of the gender-based violence model law. Ladies and gentlemen, why is the forum engaged with yourselves as legal drafters? As you may be aware, this consultation, as already alluded to by the Director of Ceremonies, forms part of a series of consultations with stakeholders on the Gbv model law. And this engagement today is because you are not only important, but you are the sine qua non of the legal drafting process of your respective member states. It is well known that without legal drafters, no law sees the light of day. It is indeed legal drafters and their subordinates in ministries of justice and parliaments who take on board recommendations made from a gender-based violence policy perspective and convert this policy into law. As legal drafters, this thus constitutes the vital link between policymakers and the final legal instrument, which is tabled on the floor of national parliaments. Ladies and gentlemen, naturally, legal drafters are also directly involved in ensuring that international law in the form of gender-related treaties, conventions, covenants, or model laws are domesticated and enshrined in the domestic context. This engagement of today was therefore a necessary one, and I'm confident that the draft model law on gender-based violence will be further enriched with your valuable comments. Some of you may not know much about the SADC Parliamentary Forum. Safe to say, we are an organization on institution of parliaments in the SADC region. We represent the voice of parliaments. We are invested in capacity development and ensuring that members of parliament take advantage of their mandated role as enshrined in all our constitutions. Before I go any further, I wish to also highlight that the SADC model law on gender-based violence falls on all fours within the mandate of the forum. as earmarked under our strategic plan of 2019 to 2023. The strategic plan of the forum has envisioned that the forum must act as a flag bearer of democratization and socioeconomic development in the SADC region. In this respect, promoting gender equality is one of the hallmarks of the SADC Parliamentary Forum. You'll certainly agree with me that gender-based violence is incompatible and repugnant to the notions of gender equality and socioeconomic development. Individuals of both genders cannot live in peace and dignity in an environment which is polluted by gender-based violence. Furthermore, individuals of both genders who are victims of GBV are less likely to be able to tap the opportunities existing in life, whether it is in education, employment, or conducting business. Over the years, gender-based violence has thus become a social phenomenon that harnesses oppression, subjugation, and repression within the household and at work, and it destroys democracy as we know it. Ladies and gentlemen, in addition, the forum has positioned gender-based violence on its radar, particularly because it is a contravention of several human rights, such as the right to physical integrity, the right to health, and in very serious gender-based violence cases, even the right to life. In constitutionalism, the state, as duty holder or bearer towards SADC citizens, has a duty to protect individuals against inhuman and degrading treatment or punishment. And in this regard, must enact any primary or subsidiary legislation as appropriate. The SADC Parliamentary Forum thus leads the process because model laws are forward-looking legal instruments which herald the way for member states to espouse best practices and adopt legal provisions on gender-based violence with the model law as a guiding benchmark. Some may ask, how does the model law on gender-based violence fit within other regional initiatives? At this juncture, it's opportune for me to emphasize that the SADC model law on GBV is not a self-standing regional measure in the midst of other SADC initiatives. Indeed, it is congruent with the broader SADC regional strategy and framework of action for addressing GBV as contained in the 2018 to 2030 strategic framework. While the regional strategy calls for human rights compliant legislative provisions which outlaw all forms of GBV, the SADC model law on GBV hits the nail on the head. Indeed, the model law constitutes of legislative provisions that embodies the gender-related objectives under the SADC Protocol on Gender and Development, Sustainable Development Goal number 5 on gender equality, the Beijing Declaration, as well as Aspiration 6 of Africa Agenda 2063 on women and youth empowerment, among others. The gender-based violence model law is thus a consolidation of regional efforts as well as international efforts made by member states to address the various predicaments caused by gender-based violence. Having said that, allow me to speak to the issue of the importance of soft law. To say a few words on this, allow me to emphasize the effectiveness of SADC model laws in general, bearing in mind that the SADC model law on GBV, which is the subject of today's consultation, constitute what you refer to as soft law. Since you are legal drafters and are thus all qualified in law, you'll be conscious of the concept of dualism under international law, in accordance to which member states must incorporate international law by domestic legislation for the international law to have any domestic legal effect. The same would apply for the SADC model law on gender-based violence, which will be persuasive in nature rather than binding. However, I believe you can all attest to the necessity of regional instruments as persuasive material that is commonly used in legislative drafting to benchmark draft national laws that are in the process of preparation. Indeed, some of you will be reminiscent of how the SADC model law on HIV and AIDS and the SADC model law on child marriages, the SADC model law on elections developed earlier by the forum have contributed to the benchmarking of new enactments or amendments made to existing enactments in the SADC region. The model laws are designed to act as a catalyst which accelerate the legislative process and which give the lawmaking authorities a boost in evidence-based research and legal strategy. Ladies and gentlemen, our fellow drafters, in addition, I wish to highlight that the forum does not only adopt model laws, but also monitors closely their domestication with the support of its oversight organ, the Regional Parliamentary Model Laws Oversight Committee. Indeed, once the SADC model law on GBV will be adopted, a dedicated scorecard will be developed, and the model law will be monitored by the Oversight Committee in collaboration with national parliaments. In this vein, the adoption of the SADC model law is not only an addition to a number of GBV-related regional instruments, but also opens an avenue for the continuous assessment of legislative progress on gender-based violence. Why are we having this stakeholder consultation? Dear colleagues, you will note that the forum is a staunch enabler of participatory democracy. If the model law is a product, then the end user and the end beneficiaries are individuals living in the SADC region. At the same time, the forum values its stakeholders and considers that stakeholders are the necessary scaffoldings which constitute the backbone of a participatory democracy. In this respect, it is imperative for the forum to consult widely prior to every model law that is adopted. The sensitivities associated with gender-based violence, as well as the high ranking of gender-based violence on the agenda of the forum, have triggered the need for a full calendar of stakeholder consultations. And thank you to the Director of Ceremonies for making this visible to all participants. Prior to this consultation, views were heard from SADC lawyers, from judges and judicial officers. We are planning other consultations with magistrates and ombudspersons. We've also met with jurists and representatives of police force. These consultations with legal drafters who are at the center of the legislative process thus closes the loop of public sector engagement. I wish to end by adding that the stakeholder consultation is important because your contributions are vital to the process of finalization. Indeed, we are confident that ensuing discussions will be lively and constructive to the finalization of the gender-based violence model law. You are thus invited to engage as freely and frankly as possible with the legal drafter and facilitator who will be at your disposal should you require any clarifications. On this note, I wish to thank you for your kind listening. I wish to thank you for your attendance today, and I wish you all a pleasant session. We're looking forward to your comments at a later stage, as these will be archived and form part of the compendium that gives evidence to the level and quality of our consultations. I thank you.
Thank you very much, Secretary General, for those very pointed remarks that really set the tone in terms of what we are going to be doing today. I could not help but appreciate the fact that legal drafters are the indispensable linkage between the policymakers and the model law, and that you also have the opportunity to entrench international obligations into this model law. I also took note of the pledge by the Secretary General that SADC-PF stands as the staunch enabler of participatory democracy, and I'm sure that participants can hold SADC-PF accountable to this pledge, because we really go out of our way to make sure that stakeholders do participate in such processes. Secretary General, with your indulgence, allow me to, realizing that we are not too many in terms of the countries that are represented, I'm going to request that participants do introduce themselves by country. The challenge of virtual meetings is that sometimes you can be in the same meeting and not get to know that you were in the same meeting. So to try and bridge that, allow me to take the next 10 minutes to invite stakeholders, to participants to introduce themselves by country. I'll start with Angola. Angola, you have the floor. While Angola is getting ready, allow me to invite. Yes, Angola, you have the floor. Was it the interpreter speaking? No, that's okay. Okay. While we wait for Angola, I invite Botswana. Please introduce yourselves, our participants from Botswana.
Good morning.
Good morning. Could we see your face, please, if you don't mind?
All right.
Thank you.
Just a second. Let me get this. That's me. Good morning.
Thank you very much. Morning. How are you?
Very well, thank you. My name is Gbv Law, as you can see. I'm the acting parliamentary counsel for Parliament of Botswana. And I have a team with me of drafters here based at Parliament. I'm with Ms. Mwibei Patsimo, if you could just switch on so they see you, and Mr. Sello. Thank you.
Well, thank you very much, Botswana. We appreciate your presence.
All right.
Sure. Can we move to Lesotho? While Lesotho is finalizing the makeup, we invite Eswatini. Madagascar. Madagascar, do you please introduce yourselves? Diadame? Yes, is that Madagascar? Shall we have Malawi? Hello? Shall we have Mauritius?
Good afternoon. Hello. Hello.
Good afternoon. How are you, Navin?
I'm good. I'm Navina Pasraman. I'm Principal State Counsel and I work for the Attorney General's Office in Mauritius.
Thank you very much for attending. We appreciate. Namibia?
Good morning. Good morning, colleagues.
Good morning.
Must I show you my face?
Yes, Maria.
Yeah, okay.
Thank you.
Yeah. Let me see. Can you see me?
There's a bit of blaring with, yes, that's better.
Yeah, you can see me.
Yes.
I'm Maria Mahali. I'm a Deputy Chief Drafter at the Office of Ministry of Justice.
Thank you very much, Maria.
Yeah.
Anybody else from Namibia?
Yeah, good morning. I'm John Shimaneni, the Deputy Executive Director at the Ministry of Justice. Thank you.
Thank you very much, Mr. Shimanen. Can we have Seychelles?
Hello.
Yes.
Good afternoon. I'm Christine, Senior Legal Officer for the National Assembly of Seychelles.
Thank you very much, Christine. Is there anyone else attending with you?
No.
Sure. Shall we move to South Africa? Tanzania? Zimbabwe? Zimbabwe, could you? Morning.
My name is Virginia, Legal Officer with the Attorney General's Office.
Thank you very much, Takaona.
Thank you.
Zimbabwe, are you the only one attending, Takaona?
I think Ms. Hove is
Hello.
Yes.
Yes.
Hello, my name is Elizabeth Woven, Assistant Counsel to Parliament, and yeah, I'm a drafter here at Parliament of Zimbabwe.
Thank you very much, Elizabeth. Colleagues, if there is anyone else who hasn't introduced themselves and are now in the meeting, please take this opportunity to introduce yourselves. There's few
good
countries.
morning.
Good morning.
I'm Tanyara Zwalinda Manyemba from Parliament of Zimbabwe, Media Liaison Officer.
Thank you very much, Linda.
Good morning. I am Anjali Dabi. I'm with the National Assembly in Mauritius. I'm the gender expert here.
Thank you very much. Anybody else? Marie? You are muted.
Bonjour.
Bonjour.
Je suis Massi Goulamali, députée de Madagascar. Je suis la vice-présidente de commission genre au niveau de la SADC. et puis président de la commission genre aussi à l'Assemblée nationale. Merci et bonjour à tout le monde.
Thank you very much, Honorable Gulamali, and welcome to the meeting. I'm sure you are going to enjoy the meeting. At this juncture, in the absence of anyone else requesting the floor, I have the pleasure of inviting our legal drafter, Madam Eva Jala, to take the floor and lead us into the next session. Over to you, Madam Jala.
Good morning, everybody. With respects to SG, all the distinguished participants, my colleagues, the legislative drafters, I know we are all one family. This is your platform, and I hope we can learn a lot from you. Your points, your comments, your changes, your amendments will actually enhance the GBV model law, and I look forward to engaging with you. I'm going to take a different trajectory from what we took for the other partners. For the other partners in the consultative process, because I want to leave a lot of time for you to go through the GBV model law page by page, as is indicated in the program. So I won't spend too much time going through it. I won't go through the key provisions, because I assume you've already done so yourselves. You've read thoroughly the GBV law and are ready to play your part. I'll just go through the process that we took to come up with the GBV law, both in terms of research and arriving at the content. So I wish you good deliberations over the GBV model law. Let me share my screen with you. Sorry, I think I've got a problem with my icons. I can't see them. Okay, so can we all see the screen? Is the screen visible?
Yes, ma'am.
Yes, okay. So I want to go through the explanatory notes with you as drafters. I'll do them quite quickly, just to give you some insights, as I said earlier, and to give you the rationale and objectives behind the GBV model law. The GBV model law, as you have already noted through reading it, is that it's a useful tool to SADC member states, as it provides a lot of guidance to the draftsman in relation to key areas, key themes touching on GBV. It will save you quite a lot of in-depth research if you actually relate to its provisions. So it will give you guidance on the scope and content of the GBV provisions as provided for, or as will be provided for in GBV laws, because we take cognizance of the fact that some of you do have already on your statute book GBV laws. It will encourage national legislatures to enact GBV laws where these do not exist, or where they do exist, but do not conform with this model law, to review such laws and enact relevant GBV laws that conform with this model law. And this is because we have done in-depth research, profound research into this issue of GBV and its various components. So it will be a very helpful tool for you as drafters. It will give support to national laws during the implementation stage, especially where gaps still exist. The users may use it for constructive interpretation to fill in certain gaps. It is a yardstick to national policy analysts, legislators, and implementers as to best practices in enacting and dealing with GBV. It reinforces a commonality of a regional approach in dealing with GBV, laws, measures, and strategies to help eliminate GBV. And this is quite important. And you'll see why when you get to the part dealing with application and jurisdiction of the GBV model law. It's a stimulus for debate, awareness, and advocacy. This is because of its very nature as a model law. Not only do we look at the legislative aspects, but we look at the socio-economic aspects, such as policies, financial and budgetary issues for the support of GBV. We also look at the administrative structures that are needed to help eradicate GBV and support victims. So what is the rationale and objectives of this model law? It basically is a governance tool to assist member states develop and enact national laws on GBV, or revise or reform existing laws on GBV in order to meet the international, intercontinental, and regional commitments relating to human rights, and more specifically against gender-based violence. I'm sure your reading has shown that we have taken a human rights-based approach in dealing with GBV. And you can relate to that because most of your constitutions actually deal with the issue of human rights. The underlying rationale is to protect victims and probable victims of GBV, punish perpetrators, and ensure that human rights are upheld in accordance with international, continental, and regional standards and requirements. As you all know, as lawyers, GBV covers domestic violence, sexual harassment in the workplace, human trafficking, and sexual and emotional abuse, economic violence, etc. When referring to GBV, we should always bear in mind that the discussion is not just about the act of violence, but also about education and prevention, as well as victim assistance. That's why GBV laws are drafted in a special manner, where you incorporate all the aspects of GBV and its support structures, which is very, very important, Some of you as draftsmen may think that those are administrative matters which must be taken to subsidiary legislation or just to be dealt with at ministries, the police, and so forth, the law enforcement officers. But for GBV, you need to build in much more normative and structural elements in the Act, instead of leaving it to law enforcers to deal with those structures. As you know, in the realm of GBV, discretion becomes a curse. You are leaving you are bringing ambiguities, leaving lacunas in the law which can be abused. So it's a special type of legislation which must be drafted in a manner that will ensure compliance. So we have to take aware of this particular point. We must make ourselves aware of this particular point. GBV not only has terrible effects on the victim, but impacts negatively on society at large, with serious social and economic consequences. That's why we say it's a special form of legislation, a special form of legislation. It is a national issue, which requires drastic national interventions through the highest tool of governance, which you all know is the law. We are not saying that the law can fix it all, but the law can contribute to effective enforcement and compliance. That's why it's so important that as draftspersons of the region, you participate effectively in this consultative process and ensure that the law will do what it's intended to do. We all know that GBV is an affront to human rights. And that's why we emphasize the issue on human rights, as you have read. Let us look at two particular related definitions. The first one is the UN definition of what GBV is. It is any act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in public life. The SADC definition, which is similar to the UN definition, states that it is all acts perpetrated against women, men, boys, and girls on the basis of their sex, which causes or could cause them physical, sexual, psychological, emotional, or economic harm, including the threat to take such acts or to undertake the imposition of arbitrary restrictions on or deprivations of fundamental freedoms in private or public life, in peacetime and during situations of armed or other forms of conflict. So in this model law, I've ensured that all the components emanating from these two definitions were taken into account. And you shall see this in relation to the interpretations and the golden thread that actually you find going through the entire model law. The issues relating to both the normative elements and the structural elements of the legislation are built around these two definitions. Let us look at our research that was done prior to drafting the model law and what we found in relation to national laws on GBV. Our findings were that although the majority of SADC member states have laws in one form or the other dealing with some forms and components of GBV, these do not seem to be stemming or eradicating GBV. Most member states' legislation have certain loopholes, lacuna in the legislation. Provisions lack scope or content, are fragmented, inconsistent, conflict in allocation of mandates, are fragmented, inconsistent, conflict in, are ambiguous or generally vague as to meaning, privilege, entitlement, or right. And that's a very serious finding, which you as drafters must take cognizance of. The laws lack adequate access to justice provisions to enable and capacitate the various players in the criminal justice and administrative systems at various stages to prevent, receive, investigate, attend, prosecute, and decide on GBV cases and enforce decisions and protect victims of GBV. That your laws are of general application, meaning that they look at the general justice, criminal justice system, and apply that in the handling and prosecution of GBV cases, which is very inadequate. The traditional method of investigating crimes and prosecuting them is very inadequate when dealing with GBV cases. So we found that most of you may need to relook at that area of your laws and see how you can adjust them or adapt them to relate more to GBV cases. They lack adequate compliance and enforcement measures, making the law inefficacious and not having the impact it was intended to have. Some of your laws actually sound good, and the aim is actually to try to eradicate GBV. But the complement, meaning the end provisions, tend to be quite weak. And that's the concern. And maybe the sound are actually going up because people can get away with it. In most, they lack adequate provisions to ensure sufficient and sustainable resources, resulting in lack of administrative and financial capacity to deal with GBV. Most of the proponents of the fight against GBV actually recommend that an effective way to deal with GBV is to ensure that there's adequate resources built into the GBV law to ensure the availability for the management, investigation, assessment, and prosecution and enforcement of GBV cases. And that's the kingpin, which has been missing in most of our legislation. lack of provision acknowledging and addressing the nexus between statelessness and GBV on the one hand, and forced migration and GBV on the other hand, including inclusion of asylum seekers, migrants, and others on the move. This is so scary because the majority of your cases don't even touch on such vulnerable groups. Yet they are living within our jurisdictions and they require equitable, equal treatments as your own citizens. This is done in the form of humanity. Humanity. The fight against GBV is not only restricted to your own citizens, it goes beyond that to all persons, the populace living within your boundaries. That will take us neatly into looking at the national legislative and institutional frameworks. We found that currently issues related to GBV in member states are regulated and managed by various ministries and statutory authorities with complementary support from the private sector, especially civil society organizations. In most of our member states, there are no independent single regulators or management units dealing with matters relating to or impacting on GBV. The institutional frameworks include gender commissions, prosecution authorities, legal aid services, women's clinics, the police service, victim support units, the judiciary, civil society organization, and workforce and institutional-based units. These have got all the functions relating thereunto pertaining to their particular area of concern. So it's not a holistic or all-government approach in the handling of GBV cases. It's quite fragmented, although underpinned by the criminal justice system. We need to relook at this framework for dealing with GBV to make it more effective. So, for effective and efficacious handling of GBV cases, member states require legislative and institutional frameworks that provide adequate measures, strategies, programs, and interventions to deal with GBV, including adequate capacity building of critical role players and stakeholders for effective and sustainable prevention, monitoring, and management of GBV cases. So you can see we are proposing that you go further than the prohibitions provided in your legislation. You bring in the structural elements of GBV a little bit more. You bring in the supportive measures and strategies to protect the victim of GBV. So that's what we are looking at it. Because it must be a whole government approach, the legislative institution should encompass that approach. So it's important to ensure that the law provides an adequate institutional framework for engagement of all players who regulate manage, and are affected by GBV by providing for a clear system for coordination, communication, and collaboration. To add, and consultation among all the players when dealing with GBV cases. And you must provide in the law clear lines of responsibilities, the requisite linkages that is required in any institution of the law. You need the linkages. Without the linkages being created in your GBV law, then the fight against GBV will be unsuccessful. And that's why I keep saying and reminding you, this is a special kind of legislation, which you need to ensure effective engagement. The incorporation of both normative and structural elements into this tool called the primacy of legislation. Legislation is prime because it emanates from the Constitution, because the Constitution actually specifies the instrumentalities of the state, which one of them is to protect the human rights of its citizenry and the peoples living within its borders. That's an inherent instrumentality of the state. So you need to bring it together. And that's why we look at it based on the human rights angle, so that we effectuate the most important instrumentality of the state, the protection of human rights and freedoms. So the regulatory and institutional framework must be clear and certain on issues such as extent of regulatory and investigative powers, functions and duties of key role players, procedural requirements, access to justice, coordination, communication, and collaborative issues, enforcement and compliance mechanisms, and management of infrastructure, facilities, among others. The victims of GBV and the private sector involved in providing services, advice, assistance, protection to victims of GBV need assurance that regulatory state authorities have the necessary autonomy, power, and capacity to act fairly, transparently, and decisively when responding to GBV cases. So I'm sure you read in the parts dealing with access to justice and effective response to GBV cases, the holistic way we have dealt with it in the model law. So we urge you to closely look at those chapters to see whether we have actually captured all the necessary components of providing effective responses and ensuring that every member of society will have access to justice as is required by our constitutions. We have made a paradigm shift in the way we manage legislative systems dealing with GBV. And you can see from what I've already spoken on. But we want to go a little further and state that laws on GBV should aim at providing a four-pronged approach towards achieving a paradigm shift in your legislative systems dealing with GBV. And these are mere 4 examples. Provide a human rights-based approach to GBV laws that address the root causes of GBV and allows for inclusion of all marginalized groups, including refugees, asylum seekers, stateless persons, and persons without documentation, and migrants, and ensure that such approach is actually applied by all respondents, meaning the support provisions in the legislative framework, in your acts of parliament, the compliance provisions, the enforcement provisions are actually locked in the legislation. Interface all concepts, rules, and principles of access to justice to promote seamless connectivity for efficient handling, investigating, prevention, prosecution, protection, and enforcement of all GBV cases. In doing so, you'll discover, as we have in the GBV model law, that you may need to change old common law principles, rules, and concepts relating to access to justice. These, in some of your constitutions, are embedded. So you may need to go a little further to amend your constitutions to the extent possible in order to change or to incorporate better principles, rules, and concepts relating to evidence. This is not an easy task. As draftsmen, we know by our training and by our experience that changing old traditional principles, conventions, legal concepts is a difficult task. It takes a long period of time, as you have learned through your jurisprudence. But we need to start somewhere. And the best starting place is always the law. Statute law can help change some of these archaic evidentiary rules because it's a primary legislation. It's primarily legislation, which emanates from the Constitution. And the Constitution will actually deal with these concepts and principles in such a way that as long as it's applied in favor of human rights or the interests of the persons living in their boundaries, it can be done. Because you'll be stuck in the traditional way of dealing with criminal cases. And the criminal justice system, as we speak in most of our countries, is not favorable in ensuring justice is done to a victim. Yes, we acknowledge jurisprudential rules, but we also know that legislation can assist us in getting rid of some of the archaic rules and evidentiary rules that actually are obstacles in the fight against GBV. You must try to introduce innovative methods to deal effectively with GBV. For example, in these times of COVID, we need to be innovative because GBV cases are going up. They're becoming more horrific in their extent, and ensure adequate information and financial resources are provided for intervention, prevention, protection, enforcement, regulation, and that measures will work, be maintained, and will be sustainable. When doing our research and when I was drafting this model law, I took cognizance of all your constitutions and the human rights embedded in those constitutions. Because I understand, as a drafter, you need to take into account your constitutions when drafting, adopting, adapting, and enacting the contents of this GBV model law into your national laws. Because I understand that the principles of intravirus and ultravirus will apply to both substantive and subordinate legislation. So while doing so, use your experience to ensure that consequential amendments, if need be, will be introduced at the same time as or before the GBV model law is tabled. Most member states have Bill of Rights, as I said, embedded in your constitutions, which, though not comprehensive in some of your countries, some of them deal with it very comprehensively, others no. They mainly follow closely the human rights spelled out in the Universal Declaration of Human Rights. International human rights instruments provide an agreed set of human rights standards and establish mechanisms to monitor the manner in which human rights and freedoms are implemented. So these should be closely interrogated to see the extent of the human rights provided in your own constitutions. Other key human rights treaties of the UN that must be taken into account include the following. I've made your work a little easier by actually going through the entire scope of human rights instruments, which you shall see listed in the model law. And I won't go through them because they're quite a lot. So all these we have taken into account and tried to comply to the furthest extent possible with the provisions in coming up with the GBV model law. Let me warn you that this list may not be exhaustive, and as drafters of national legislation, you should endeavor to summarize all your state's obligations at international level and analyze these and fill in the gaps in national laws where these do exist. Let me draw your attention to some tools that will assist you during your research. The UN has issued a number of legislative guidelines, guidance notes, explanatory notes, and commentaries on various human rights instruments, which act as good working tools to the drafters of national legislation for a gap analysis on your national laws impacting on GBV. Some of the main recommendations have been incorporated in this GBV model law. So you can trust me as a senior drafter that yes, I have incorporated to the extent possible these UN recommendations. The GBV model law does, as far as possible, take cognizance, as I said earlier, all constitutional requirements of member states. Let us look at now at the issue relating to the current criminal laws on GBV, which we urge member states to undertake a profound review of them. We urge that the review should aim at conforming the national legislation with this GBV model law and other international and regional requirements and standards. You may need, in the process, pass consequential amendments to fit in with your revised GBV laws. Because obviously, we don't want to create inconsistencies and disharmony in the regulatory space. Because if we do that, it will disadvantage the victim. It shall defeat our fight against GBV. So when you are reviewing your current criminal laws on GBV, please interrogate gaps which may bring about inconsistencies or disharmony, an impact on the manner GBV is perceived, prevented, handled, investigated, prosecuted, decided on, and enforced. May I just point out to you, when we're talking about a gap in legislative drafting, as you know, this may be manifested as a failure in the coverage, comprehensiveness, inclusivity, rationality, or appropriateness of the legislative framework, and how it impacts on the institutional mandates of the various players in the justice and administrative system. This is very important because what we are urging is a holistic review to cover every gap conceivable. I know as draftsmen, you know how to harness the future in order to solve a problem. These gaps may include overlaps, conflicts, or inconsistencies within the legislative framework that might result in uncertainty, overlaps, conflicts, or ambiguity in the law that creates challenges or obstacles in managing GBV. The offenses, penalties, and compensation regimes need careful planning and drafting if GBV is to be eliminated or prevented. We've tried to do so in the GBV model law, but a piece of advice or a step in caution is that we do not provide for police law enforcement provisions or powers to enable enforcement or ensure compliance, such as search, seizure, and arrest. These should be provided for adequately by yourselves in national laws. We may only give you pointers in this respect. So the drafters, you as drafters of national legislation, may wish to refer to regional and international guidelines and recommended practices that provide for police and law enforcement duties and responsibilities. For example, the Essential Services Package, ESP, is a good guidance tool identifying the essential services to be provided to all women and girls who have experienced gender-based violence, including services that should be provided by the health, social services, police, and justice sectors. This package also provides guidelines for the coordination of these services. It provides standards and guidelines for health personnel, police and justice players, social and health services, and for coordination and governance of these. SADC has similar guidelines for the region. So I urge you as drafters to find these tools and use them to improve or enhance or revise or amend your legislation. National legislations should consider a range of enforcement and compliance provisions to give effect to the Gbv model law and effectively prevent or deter Gbv happening. The following key factors should be considered when reviewing and crafting or drafting Gbv provisions into law. The extent to which the root causes of Gbv are addressed with a view of migrating or eradicating them. The extent and nature to which Gbv is provided in criminal and administrative law. Don't forget administrative law. It plays a big role in the fight against Gbv. Whether the Gbv offenses provided for contravene fundamental provisions and the language of this Gbv model law. Why I brought in the language of this Gbv model law? Because we have crafted the provisions in such a way that we've captured the essence of the requirements of most member states' international obligations, including definitions done at international law. And that will greatly help you in providing a commonality of approach in the SADC region for effective enforcement. Whether the offense of Gbv is provided for in the law and what the extent of the prohibitions are. You know, when I was reading some laws relating to Gbv in some of the member states, I found the prohibitions were so weak, or the offense of Gbv not really coming out, not coming out. So that in itself makes charging of such an offense very difficult for law enforcement officers. They are so weak that they will defeat the intentions of the legislature in the fight against Gbv. Whether the offenses, penalties, and compensation provisions are adequate and fit the offense specified. And you'll see in relation to this issue of fit the offense specified, we've outlined a number of issues in the access to justice part of the model law, which you can effectively use to counter any problems that do exist as currently in your national laws. Whether adequate investigation powers are provided for to enable evidence to be easily gathered, assessed, and used to obtain a conviction for a Gbv offenses. And this is a specific weakness in most of our legislation. The issue of the investigative powers, the manner in which law enforcement officers should actually assess evidence to ensure a conviction. Because we all know how Gbv is manifested. We all know. We cannot hide our heads in the sand like an ostrich. So we actually, in drafting our laws, looking at what practically happens in society and transforming it into legislative provisions so that we can effectively fight the problem. And we can only do so if we can put adequate solutions in our legislation. Whether procedural fairness and justice are firmly embedded in the law. Procedural fairness and justice, the process, the procedures to attain or access justice should be visible in our laws. Currently, it's invisible. Whether there is commitment to address impunity and delays in the course of justice. We are lawyers. Some of you have practiced in the private sector. We know what happens in practice on the ground. The impunity of some law enforcement officers when dealing with GBV cases. What can we do in the law to ensure we eradicate such impunity and delays? The model law has attempted to put down some issues in there. We were addressed by the police sector when we consulted them, and they agreed that yes, this impunity does exist and we need to manage it. We need to manage the delay in handling GBV cases, the prejudices and the biases. So, an inefficacious legislative framework on GBV may result in increase in GBV cases, lack of access to justice, continued inequities and inequalities in society. And the SG touched on this in her welcoming address, thereby having a negative impact on socio-economic development and continued non-observation and contravention of an individual's fundamental human rights and freedoms. The GBV model will enable you as member states decide on whether to retain the status quo as provided in your existing institutional and legislative frameworks, amend some laws dealing with or impacting on GBV, or indeed ensure that they deal comprehensively with GBV and provide effective access to justice provisions, thus creating an efficient and sustainable criminal justice and administrative systems for the fight against GBV. We should not, as draftsmen, get stuck in the mud. We should be forward-looking. We should be all-encompassing in the way we approach the drafting of GBV legislation. We are, as we always state, even during our training, social, economic, and political animals. We live in the societies that we find ourselves. So we need to use that experience to ensure legislation is organic and it does touch on the socio-economic problems of our societies. We cannot ignore this. You are the interrogators of policy. While you are handling your instructions, you are allowed as draftsmen to add value to your instructions. And the value additions in your instructions pertain to your role as a lawyer, looking at your constitutions, existing legislation, international obligations, and so forth. You are the safeguarders of the Constitution. So your value addition is allowed in policy direction through the understanding of your instructions and transforming the policy into effective legislative frameworks. At least I've been drafting for nearly 40 years, and I know I have used my skill to promote good quality legislation. As envisaged in the our constitutions. And our constitutions are very key on the welfare and good governance of our societies and their people. So there's no excuse in relation to that. Those are basic principles of all our constitutions. And these days, in more contemporary constitutions, they're actually laid out as principles to be observed in the implementation of policy, the enactment of legislation, and when deciding cases in the courts of law. Regulations under national laws on GBV. We've gone a step forward in this model law by trying to help member states in coming up with regulations under their national laws on GBV. So you find that the GBV model law gives member states a general guide to the content of a law on GBV, which can ensure efficacious legislative content for national laws, while taking into account regional specificities. We've looked at all your laws, your constitutions, and we said, fine, we can not draft a law specific to one country, but we can take into account the specificities of each country within the region and recognize them. So it is imperative that member states must, after enactment of their laws on GBV, which may not be comprehensive as to measures, intervention, administrative support systems, procedures, and processes, to exercise legislative authority through the making of subsidiary legislation to operationalize the law on GBV. As you know, regulations are effective implementation tools to bring in generalized administrative, in-depth requirements that the law has laid out in your regulations. Because you can now bring in what is special, what is workable, what is practicable in your individual member states. So it's flexible enough to ensure that you can actually bring in best practices which are already within your state. Bring in other practices which you think will help you bring about an efficacious regime to deal with GBV. So you'll find that the GBV is a strange piece of legislation because it deals with both the substantive issues and the subsidiary matters. This is deliberate to guide you as drafters as to the extent of the law. So the extent of the law, when you go back home, you say, no, this will put into the substantive act, these will leave for the legislation and for the regulations. So even the regulatory aspects have already been included to help you to operationalize the law very quickly and saves you a lot of research. Another problematic area that we looked into when coming up with a model law is the issue of customary laws and religious norms, which, as you know, plague us drafters when it comes to drafting legislation touching on human rights and freedoms. It really plagues us. These customary laws and religious norms impact greatly on women's and children's human rights. Some of them offend international commitments made on GBV by member states. Some of them offend good governance and are repugnant to natural and legal justice. And we all know that our constitutions tries to prevent the use of customary laws and religious practice where they're actually repugnant to natural justice. Some of our judicial legislation have provisions in relation to this matter. If you're looking at some of the local government, what you call this, the magistrates' rules and enactments, the High Court rules and enactments, you find this particular sentence coming in and over, in and over. Customary laws, why it's a nuisance is because customary laws are recognized as sources of law in most of our member states, especially where these are not or are inconsistent with the Constitution or an act of parliament, or are repugnant to natural justice. Further, most of our constitutions recognize the freedom of religion, the freedom of religion. So these become a little problematic when dealing with such issues. What member states should do is to assess their customary laws, religious norms, and practices and attendant institutions. And where these are found contrary to the provisions of the Constitution, an act of parliament, and we urge you, this GBV model law, or are indeed repugnant to natural justice, to reform or amend them so that they conform, Without such an exercise, the fight against GBV will be futile, because the right hand doesn't know what the left hand is doing. And this has more impact on rural communities, where the traditional way of doing things is still very prominent. Acts of general application. As drafters, you all know that you must consider statutes of general application when adopting or adapting this model law. These are statutes that generally apply to all laws in your country's jurisdiction. For example, the Interpretation and General Provisions Act, the Statutory Portfolios Act, criminal laws, evidence codes, and financial management laws. Without doing this, then you may create a problem in the fight against GBV, because they may be contradicting other laws of general application, which we don't want happening. The SG has talked about domestication, which is very important when you are drafting such a law. And you have seen we've got so many conventions and protocols relating to GBV. As lawyers, you should always bear in mind the Vienna Convention on the Law of Treaties of 1969, which obligates member states to abide by their international commitments. They cannot use municipal law as it currently stands as an excuse to veer away from their international obligations. Because as you know, international law consists of its own realm of rules, concepts, and principles, and standards which apply to the conduct of member states and international organizations in their relations with one another, and in some cases with individual groups and transnational companies. The commitments and obligations of states emanate from these rules and standards. So a national drafter must take them into account when drafting GBV laws. In the GBV law, I try as far as I can to provide guidance for the domestication of various regional and international instruments on GBV in accordance with member states' obligations. I don't want to go in too much detail on domestication, because most of you understand what your own method of domestication is in your jurisdictions. Some of you will follow the dualist concept, while others have a self-executing system, which is monist, for the domestication and international of your international obligations. Just a pointer that globally this has become very standardized, the method in which you domesticate. Yes, there are various methods, but some I may point out to you are as follows: reflecting the principles of their content or text in the national law, either directly or in a contextualized manner, setting out the text in the national law, either in full or in part, giving full effect to the regional or international instrument by reference, and annexing the instrument as a schedule to the national law, or indeed a combination of any of these. But you've all got your style and norms on how this can be done. You'll find in this GBV model law, we use a number of words and terms defined in regional and international instruments on GBV, and where used in this model law, these are defined as provided in the regional or international instrument, with some modification to achieve simplicity and ease of understanding. That's the extent to which we go. But we actually adopt the international interpretation. It is important that language is adopted in the national legislation, adapted in the national legislation to reflect the most up-to-date terminology in the field. So it's important that if the way binary persons is now defined in international law and the GBV model law doesn't go to the full extent, then you have to use the one which is the latest. We've tried in the model law to ensure that the appropriate level of competence is given to the right functionary. And we've built into the model law procedural fairness. And we've defined all the necessary terms. Where discretion is given, it is to be exercised proportionately or comparable in relation to the nature of the decision being made. And we all know that discretion is not a favorable of most drafters because of its very nature. It can be abused. So we have to be very careful the way we handle issues of discretion when we're allocating powers and functions to these functionaries dealing with law enforcement and so forth. An appropriate authority, a competent authority, judicial institution, or quasi-judicial body must act in a manner which affords procedural fairness to victims of GBV. They must be and appear to be free from bias. Gender bias is the curse of most of our procedures. We need to ensure fairness, equity, and equality in the processes that we employ. Survivors and victims of GBV must be given a fair opportunity to provide any relevant information before a decision is arrived at, and that decision must be explained in a way the victim of GBV can easily understand, regardless of their background, nationality, or lack thereof. So what is the focus of the GBV model law? I'll try to finish off quickly to give you a chance to start your discussions. It's important to emphasize that while the focus of the GBV model law seems to be more on violence against women and girls, the GBV model law also has a gender-based approach as it applies and is of relevance to violence against men and boys. The provisions of the GBV model law should be read broadly to apply to all forms and components of GBV, to the extent of the UN and SADC definitions, to all victims and perpetrators of GBV, be it non-gender binary people, heterosexual, lesbian, bisexual, homosexual, transgender, or people within the same-sex relationship, or sex workers. I know most of you would say you have a problem, both constitutional and policy, in relation to this issue in coming up with such legislation. But then you need to take it step by step. You need to ensure that your countries have an engagement process with other countries who have dealt with this issue. We are not saying do it immediately, otherwise you may defeat the very purpose of what we are trying to do, is to get GBV on our statute book. So be circumspect in the way you deal with some of the issues. However, in general, regardless of orientation and occupation, women and girls are more vulnerable to and experience more sexual violence, more severe physical violence, more abuse and more control, largely from males. And that's the reason acute focus is made on women and girls who are disproportionately affected by GBV. Further, the underlying logic of the subject areas of the GBV model law bear in mind the various categories of users of the GBV model law, who will be responsible in SMSs for developing, drafting, approving, enacting, and implementing this law, or who have an interest in monitoring and evaluating the efficaciousness or impact of the GBV model law. So you see some provisions relating to these issues flowing through the GBV model law, which can be used by yourself as national drafters. So I want to skip all these other issues because I think this is the concept based on the SADC conceptions as to GBV. I've talked a little bit on COVID-19 considerations, and I'm sure as drafters, you need and you know that you need to take into account the special circumstances that we are in these days relating to COVID-19, and try to address the various aspects relating to GBV in the context of the COVID-19 situation. I want to point out to you here the form. The GBV model law is structured in the style and form of the approved, adopted SADC model law on child marriage and protection of children already in marriages, and the SADC HIV/AIDS model law, as this sets a good precedent that has been established by SADC-PF on structure and form. This will also assist the SADC-PF build a compendium of model laws that are authoritative. The GBV model law, therefore, does not conform to any individual member state's form or structure of legislation. It does not. You have got your own styles, your own form of drafting legislation, So you'll be doing so when drafting the GBV law. It's very important because we don't want to dwell in the next few minutes on structure and form. We don't want to dwell. We want to deal with substance. We want to deal with content. So you'll find that it does not have a memorandum. It doesn't have a long title or short title, but has a preamble which outlines SADC member states' regional and international commitments on human rights and gender-based violence as spelled out in these instruments. So you're going to have to read your preamble. I'm sure you've already read it. It cites various programs, strategies, action plans, and conventions related to GBV. So a lot of work has already been done for you in this respect. So I'll stop there now to give you a chance to actually go through the model law with me, page by page, if you want to do so, or if you've got a better way that we can use to incorporate your comments into the model law. I'll be happy to listen to this and incorporate them when I start doing the final draft. Thank you so much for listening. I know it may have been a long session, but it was necessary so that we are all on the same platform when we are discussing the model law. Thank you very much, SG. Mr. Moderator, I hand over to you.
Thank you very much, Madam Eva, for that very comprehensive presentation. I'm sure the colleagues agree with me that they've been able to appreciate the context and the scope and the provisions of the model law because of the presentation. At this juncture, before we go to the next session, maybe if there are any questions, we could allow for those questions to be asked. Are there any questions? You may indicate by raising your hand or even verbally indicating that you want to speak. Are there any questions and comments? I don't seem to see any questions, Madam Eva, which suggests that the presentation was well understood. At this juncture, let me hand it back to you to take us through the model law. You can proceed to get the consensus of the House on the question that you had posed before I took the floor. Over to you, ma'am.
Thank you very much, moderator. Participants, colleagues, how should we proceed in handling your comments on the model law? I need your guidance, the most effective way to proceed. Participants, can you suggest the most effective way to proceed in incorporating your comments or amendments into the model law? What's the most effective way for you? Do you wish to go page by page or section by section?
That's maybe page by page.
Page by page. Okay, we'll start with the preamble.
While you have the floor, Madam Jala, just to indicate that the pages might be different in the different languages. So probably the proposal to go section by section might therefore assist in making sure that everyone is following.
Okay, thank you very much, Mr. Moderator. I hope our Mr. Jere, who's taking down the notes, is ready. This is the most essential part of our work today. And I need every comment and amendment taken down. Are you around, Mr. Jere?
Yes, I'm around and I'm ready. We can proceed.
Thank you very much. Can we look at the preamble to the model law? The first part of the preamble, bearing in mind, recognizing, understanding. Do we have any comments on those paragraphs? If I hear silence, I would assume there's none and I'll proceed. I'll give a minute for a reaction before I proceed. I don't know why I think, Marie, you want to contribute, but you are hesitant. I can see you. Would you like to contribute, Marie?
Madame Jala, Honorable
Non, merci.
Marie. Ah, okay, sure.
Je vous écoute. Merci.
Thank you very much. Can we turn now to continue with the preamble? Recognizing, acknowledging, bearing in mind. Any comments on those paragraphs? Let's continue. Paragraphs dealing with taking due account. Daniel, I can see you. You are muted. You are muted. I can't hear Mr. Moderator. He's muted.
Daniel, are you seeking to take the floor? You are muted. ICT, could you help us unmute Mr. Daniel if he's not able to unmute himself?
Hello. Hello, can you hear me?
Yes.
Yes, we can hear you clearly now. Please take your stand.
Now, good afternoon.
Good afternoon.
Now, actually, my name is not Daniel Eliufo. My name is Prudence Reyongeza.
Okay. From which country?
I am a principal legal drafter from Parliament of Tanzania, National Assembly of Tanzania.
Yes, please proceed.
Yes, now we appreciate what has been submitted today. But the position we have here in Tanzania, not in Tanzania, we are talking from the Parliament of Tanzania, Parliament of Tanzania. In fact, we are still working on this model law. Stakeholders have not yet met to make any deliberations, to make any position of the country. So what we will do, as the paper or as the program has been provided, that we shall give our written inputs by 24th September this month. So we are not giving any input today, but you are just following what is being discussed today, but we'll just give our written inputs by 24th of September, as you have just indicated in this program. So this is not the position of.
Thank you very much, Tanzania. We'll wait for your comments. We really want to learn from Tanzania if we have captured any best practices or just provisions generally to enhance our model law. Thank you.
Thank you very much.
Madam Eva, if I may also supplement to indicate to the colleague from the Parliament of Tanzania that we are going to have a meeting, a joint sitting of all SADC PF members drawn from the SADC PF committees on the 16th of this month, which is 3-4 days from now. It would be good by the time when the members come, if Parliament would have facilitated them to have gone through the draft, so that in the meeting they are able to deliberate together with the other members of Parliament of SADC Parliamentary Forum.
That's okay.
Sure, thank you very much.
Thank you.
Can we have anyone else who wants to take the floor? I see none. Can we go to the paragraphs now on conscious that Article 21(2), noting Article 2, noting the worth of Article 4. Any comments on those paragraphs? Let's go on. In the preamble, still in the preamble, the paragraphs, noting also that Article 4 and 5, aware that Article 6, acknowledging that the United Nations Special Rapporteur. Any comments on those paragraphs in the preamble? I see none. Kelly, Bielang.
Oh, may I interrupt?
Please go ahead.
Yes. Just to say that we also got these documents today, so we will submit later. For now, we are really just trying to follow the presentation, but if there is anything, we'll react, but we'll revert later to give ourselves a chance to.
Thank you very much. That's Botswana, isn't it?
Yes, it is.
That's
Thank
Botswana.
you.
Thank you very much. May I just open the floor to the countries who believe they're not ready to comment today, but will be sending their comments before the 24th. Please, can you indicate?
Okay, so
any
it's
other
Botswana
country?
first? Yes.
Hello.
Yes. Navina?
Hello, Madam Chair. Yes, I am Navina Pasraman from Mauritius. I just wish to point out as well that we received the documents only this morning, and we shall be sending our comments by the 24th, if that's agreeable to Madam Chair.
Thank you very much, Navina. We shall eagerly await your comments. Anyone else who wish to state that they'll write written comments to us?
Madam Chair, that is the same position for Seychelles, because I too only received the documents today.
Thank you very much, Seychelles. We shall await your comments on the 24th. Anyone else present wish to make a reservation from actually commenting today?
Madam Chair.
Yes.
We shall also not make a presentation today. We will comment. Yeah.
That's Maria from Namibia?
Yes. We will not
Namibia.
make presentation today. Yes.
Thank you very much. Namibia will send written comments as well. We look forward to your comments, Namibia. Yes. Anyone else with such reservation? Because what we need is effective participation and enhancing the document. So if you can't do it today, then let's be frank with each other so we actually look at your comments through a written report. So far, I've got 5 countries requesting written comments. How many countries do we have present, Mr. Moderator? Because we've got Tanzania, Mauritius, yes, Botswana, Seychelles, and Namibia, who have asked us to give them time to provide us effective comments in writing.
Sure. So we in addition to those, we also have Angola, Lesotho, Madagascar, Malawi, and Zimbabwe.
Thank you very much, Mr. Moderator. SG may suggest having the majority of the states wishing to give us written comments. I know how drafters are. They don't want to commit themselves very lightly on these provisions. They want to study the provisions and give us good comments. May I suggest that we await the written comments from our member states, especially so that the document was only received by them like yesterday, that we postpone this meeting and we await the written comments. And if we have any problems in relation to certain comments, you may bring back a small team of drafters, very small team, to actually go through the comments before we finalize. Otherwise, if the comments are straightforward, we shall incorporate. SG, I don't know what you suggest at this juncture.
Thank you, Ms. Jala. Indeed, that seems to be a progressive way to proceed. We would not be doing any justice if we leave this meeting with no comments at all from our drafters in the region. I was listening, you only have a few. Are other countries fine, or will they also be sending comments? I've not heard. Ms. Hove, I saw you from Zimbabwe. Would you have any input in this regard? And Angola, is Angola on board?
They're coming, SG, they're giving us written comments. So let me just read the countries for you, SG. It's Tanzania, Mauritius, Botswana, Seychelles, Namibia, Angola, Lesotho, Malawi, Madagascar, and Zimbabwe, who have indicated that they rather give us written comments.
Okay, all right. That is the way to proceed. I see a hand from Madagascar. Honorable Marie-Jean.
Please proceed, Honorable.
Merci pour me donner la parole. C'est juste pour vous dire seulement, on n'a pas encore de commentaires à donner aujourd'hui et maintenant. On attend un peu le 16 pour qu'on puisse tous se réunir et on va discuter ensemble avec nos collègues parlementaires. Merci.
Thank you very much, Honorable Marie-Jean. SG, over to you.
Yes, I think some of the difficulty that we have is communication directly or indirectly with drafters, since the majority of them are hosted at ministerial level. Very few are within Parliament, and hence the communication trail of documents seems to have been affected. So we plead with you to initiate the feedback directly so that we really don't suffer through the long trail with our bureaucracies for the drafter to be able to have received them by the 24th. Also to allow us to take a decision that would lead to whether we will be able to convene another small group or we'll be happy with the comments that have been received. We will bank on your commitment at this point and also encourage other countries to do same. I thank you, Ms. Eva. That is all I have to say.
Thank you, SG. Mr. Moderator, over to you for the rest of the program.
Thank you very much, Madam Eva, and thank you, SG, for the guidance. Maybe before we adjourn, we close the meeting, may I have the honor of inviting everyone in the meeting to put their video on so that we have a photo session. We need it for our media plan. The colleagues in the media would really need to have people's videos on so that we can take photos. So please, can we have your videos on, colleagues? Cello, Maria, Mr. Shimameni.
I'm going to put it on now.
Sure. Navina. Kekeletso. Wilfred and Marofafika. George, you can have your photo on, please. Navina.
I'm sorry. Yes, I'm sorry, I'm on mute.
Thank you, Mr. Shimameni. Shimaneni. Kekeletso. still have a few gaps. Mr. Shimaneni and Kekeletso. You are invited to smile. Modise, are you happy? Are you taking the photos?
Yes, I've been taking a few already. Thank you, Chair.
George, good to see you. There's a colleague who is SADC Parliamentary Forum. Is it Ronald? We demand to see your face. And then there is also SC/AN Marotafika. There is also
looks like someone from Madagascar.
Kekeletso. Ifoma, good morning. Please proceed and smile. Ronald, let me know if you are happy with the photos you guys have taken.
Certainly, sir.
While a lot of people at least based on in panel 2, based on the setup of my laptop, who are not on video.
We're good.
We're good.
Yeah.
Okay. So thank you very much. And just to follow up on what the Secretary General said, we would like to have direct communication with you colleagues to facilitate you in terms of the submissions. We have given an email address, gbv@sadcpf.org. We also would have noted your emails from the registration that you did to attend this meeting. We shall use that information to be able to communicate with you directly so that we facilitate you to be able to submit in line with the resolution by the meeting. At this juncture, I wish to check if there are any issues that any one of us may wish to raise before we adjourn.
Mr. Moderator, just
Yes,
to ask the draftsmen from parliaments if they could assist us in getting in touch with the draftsmen who are stationed at ministries to try to participate in this exercise. Thank you.
Thank you very much, Madam Eva. It's duly noted. Indeed, there are few countries that are not represented in terms of drafters from the ministries. We would really appreciate if that happened. We shall also be following up with our desk officers at Parliament to make sure that this happens, and also to make sure that they prepare members of Parliament ahead of the meeting on the 16th. At this juncture, in the absence of any request for the floor, the meeting stands adjourned. We shall be communicating. We look forward to receiving your submissions. Thank you very much. Host, kindly terminate.
Thank you, Commissioner.